Now, let's do it. It's Do They Have a Case with Wayne? Haven't done this in a while. Wayne Resnick, who, as you know, has spent a good part of his life in the criminal justice system, so he knows this stuff pretty well, and researches the case, comes up and says, here's what's going on, which way should the courts or did the courts rule, and it's a case of first impression for all of us, meaning that we haven't heard of it before. And in many cases, there's no law on it, and we still have to decide.
All right, this is a sordid story, and it has to do with a bunch of highly educated medical researchers working at a lab. The lab is funded mostly by grants that it gets to do research. So you have the guy who runs the lab, Dr. Robert Garfield. Boom. Then you have one of the doctors that works there, William Maynor. He is the aggrieved party here. He's the guy who's upset. You've also got a couple other doctors there, Dr. Wan and Dr. Shi. Now, Garfield, who runs the whole thing, is in an affair with Dr. Shi. Takes her to professional conferences and stuff that he does not invite anybody else to, for example, and they're not keeping it a secret. They live together, and they even have PDAs at work. All right. At some point, they decide to move the lab from Texas to Arizona. So they moved the lab from Texas to Arizona, and Garfield wants everybody to come along. But Maynor can't go to Arizona because, and please don't let this prejudice your judgment of the case, he can't move to Arizona because he gets convicted of a lewd act crime with his own child and has to stay in Texas for 8 years of probation.
Why would that prejudice anything?
Well, because that's not a nice thing that he did, is it?
Okay, no, probably not. Yes.
But Dr. Garfield says, that's okay. We'll put a little office in Galveston and you can work remotely. So that's now the situation, all right? Everybody else is in Arizona. Garfield is still whooping it up with Dr. Shi, and Maynor's back in Texas. Well, his work starts to suffer, and he gets written up for doing bad work. And eventually, they eliminate his position. He sues and says it is sex discrimination under Title VII. He goes to the EEOC. Sex discrimination. Well, how is it sex discrimination? Well, Dr. Shi is still there, and she, S-H-I, is a she. And I'm gone, and I'm a guy. And that is sex discrimination. And the court says, what are you talking about? And here's his theory. It's called paramour preference discrimination. This is when you feel you're being discriminated against in the workplace because the boss is romantically involved with somebody else. So here's the problem. The lab company says, Title VII only says you can't be discriminated against based on race, religion, and sex, meaning your gender.
Right.
You weren't nothing happened to you because of your gender. Yes, it's true. He is stooping this other worker, but that's not, you're not protected. So who's right here?
Well, I don't think he's got much of a case arguing under sex discrimination, because especially if there are valid reasons for him to have been fired. And for example, the validity of the write-ups, has his work suffered? And I'm assuming that during the course of a trial to bring up some evidence. No, he just did that to screw me over. No, the work actually did suffer. But the bottom line is I absolutely agree with lower court that said it's not a protected class. It just so happens that he's a guy and the boss is stooping some woman. And what if the boss was stooping some guy? Whoa, is that sex discrimination too? So I don't know where he's going with this. I think that he has no case.
He has no case. And also, the Ninth Circuit now finally joins every other circuit. You see, this paramour preference thing has been tried a lot. I didn't get promoted because the boss is sleeping with that person. It's been tried over and over again. Every time it goes to a federal appeals court, they say, nope, There's no such thing under federal law. It's just the Ninth Circuit, I guess, didn't have a case until now. So they've joined every other federal court. No, there's nowhere to go in this country now and try this. I got discriminated against because of the romantic relationship that my boss is in. Nobody's saying that it's cool if that happens to you. They're just saying the law doesn't cover it.
Yeah, and also that, I mean, even if the law did cover it, I think they'd have a hard time connecting the dots here because it's ignoring the fact that the work was substandard. Oh, no, there's no such thing as my work being substandard. The write-ups that you gave me were ridiculous. They were... you just did that because you hate me, because you're discriminating against me. It doesn't work that way. And also, I mean, it's a little bit of an issue. You're going to take in front of a jury, and does it come out that you had sex with one of your own children and were convicted of it and therefore on probation? That's going to fly, isn't it?
Well, and that's the reason why he couldn't move to Arizona with everybody else. They were perfectly happy to have him.
Yeah, this is a particularly bad case for the plaintiffs.
I'm surprised that he got somebody to pursue it for him this far. Like if you were an attorney and somebody said, I want to go to federal court and I want to sue and here's what happened, would you want to get on board with that?
You'd be surprised how many lawyers take cases in which there is no chance whatsoever. That's happened to me a couple of 3 times when I was sued on a surrogacy matter, and the case was so blatantly completely insane that on the courthouse steps, they dismissed because they weren't going to go even in trial. And I asked the lawyer, I said, what are you doing here? You know, this makes no sense. And it was, we thought we'd get publicity out of it.
Oh, okay.
Okay, there's that one reason.
Sure.
And another one's because they almost extorted, saying, oh my God, you look at you and, all the horrible things you say on radio, and we don't want to bring those up. And I go, get in line.
They forgot that you have no shame.
That's correct.
So trying to shame you,
I know it just didn't work. Yeah, it's true. But anyway, so the point is, it makes no sense that that could have made sense. It doesn't.
So maybe the lawyer thought they'd make a name for themselves if they could get a favorable rule. Look what I did. I had sex discrimination against this guy.
Who knows? Well, lawyers are weird. All right, Wayne, let's move forward.
All right, Handel's choice. Problem with a murder trial, or problem with a lady taking videos and photos at the park and there's children.
Oh, let's do murder.
All righty. And this is also a local case from here in Southern California.
Better.
So a guy is murdered, and pretty quickly the cops zero in on some suspects and arrest them, and they go to trial. No eyewitnesses. No direct evidence linking these 2 guys to this murder. The evidence is almost entirely the testimony of an informant who says, oh, on Tuesday, that guy told me he killed the guy. And on Wednesday, that guy told me he also was involved in the killing of the guy. So they have a preliminary hearing, and this informant, says that. They both confessed to me that they killed a guy. They start asking the informant about some of his troubles, and he takes the fifth. Now they get to trial. Here comes the informant. Now he decides he's taking the fifth on everything. He is not going to say anything about anything. So the judge says, well, the witness is unavailable. He's unavailable by virtue of taking the fifth. So when a witness is unavailable, you can read their preliminary hearing testimony. So he reads the testimony from the preliminary hearing to the jury, but of course the guy's not there to be asked anything. And the jury convicts them, and now they appeal and they say, hey, you have a constitutional right to confront the witnesses against you, and here we are at the actual trial. You're reading his testimony. He's not even there. Nobody can confront him. It's a clear constitutional violation. And the government says, hey, there was opportunity to cross-examine him at the preliminary hearing, and that's good enough. Now it's in front of a federal appeals court. Is that good enough?
I don't think so. I think that the ability to confront witnesses at trial it may encompass a preliminary hearing, but to the exclusion of everything but a preliminary hearing, I don't think that's going to fly. The ability to confront a witness is so fundamental to our Constitution and to our system of justice that it's sacrosanct. And if you don't have a witness there to confront, where do you go other than the testimony that's read in? You can't refute it other than standing up and testifying in a trial that you don't have to testify to. In other words, defendants don't have to say anything, and they never do. So therefore, I guess the argument would be the only way they could refute it is for them to stand up and refute it, and therefore they're part of the case in which they're constitutionally not forced to be in. That's the way I view it. A little convoluted, but the bottom line is I don't think that is the ability to confront a witness. So I'm going to say that the defendant wins on this one.
That was a cogent, passionate presentation that you just made about the fundamental constitutional right to confront the witnesses against you. But apparently, you're wrong.
This is where I don't know.
Can you believe it?
Yeah, I don't. I don't understand that. I really don't.
Here's the thing, okay? You know that there's virtually no right that is 100% all the time, right? Like you have a right to free speech. That doesn't mean they can't have a law that says you can't use a 50,000 watt amplifier for your protest. You have a right to have a gun in your house for protection. It doesn't mean you have the right to walk around the streets with a machine gun. You have a right to confront witnesses, but it doesn't mean that you can, I want to find the quote. There's actually a Supreme Court case that says you don't have a right to cross-examination. I'm paraphrasing now. You don't have a right to cross-examination anytime, anywhere, any way you want to the extent that you might want. You have a right to some kind of basic confrontation.
Yeah,
and you had it at the preliminary hearing.
So how about at trial to confront witnesses? Are they ignoring that completely?
Well, I guess they consider the preliminary hearing part of the trial. Here's the quote. This is the Supreme Court. The Confrontation Clause does not confer an unlimited right to cross-examination that is effective in whatever way and to whatever extent the defense might wish. So you don't decide when you've had enough cross-examination. The court decides when you've had enough. And this judge decided they'd had enough. And these three judges over there agreed that they had enough. Now, here's the thing about this.
Which I don't understand.
It's going to be a case-by-case question. It's because part of it is going to have to do with, well, if he had been on this stand, what would you have confronted him about? And here, one thing is, at the preliminary hearing, he already admitted that he was getting paid by the police. And if he had been on the stand at the trial, they would have brought up another payment, an extra payment. And they said, but if the jury already knew that he had been paid, so what are you adding to that? And then the other thing is that the detectives actually opined that he was not a reliable informant. And we would have confronted him about that. And the court said, but you don't even know if he knew that they thought he was unreliable. So part of it has to do with the specifics of what you would have brought up.
Crazy. All right. Well, 1 for 2, but I would go 2 for 2 if I had my druthers on that one.